evening, ladies and gentlemen. If we could gather, we have a tight schedule. So just in the beginning, I want to let you all know that this is being live streamed. So as you are presenting, please pay attention to your slides. You will have to advance them manually by saying next to Miss Smiley, who's up in the booth. And I think we are ready. It is almost 6 o'clock, and I want to make sure that we are on time for the people that are joining us online. So thank you. Good evening, and welcome to our legislative town hall on our new housing laws. We're grateful to the Reverend Dr. John Foster for opening the doors of Big Bethel A&E for this community discussion. My name is Cassandra Kirk, and I have the pleasing honor of serving as your Chief Magistrate Judge in Fulton County. Today I will facilitate a very important discussion. Today's event brings together a series of experts who will provide insight into the various aspects of our housing laws from their unique perspectives. We'll cover crucial topics, including the operations of the Magistrate Court, the role of the marshal, updates on new housing legislation, and essential information on rental assistance programs. Our goal, as always, is to inform, engage, and empower you, our community members, by providing clear and actionable information on these critical issues. Through this open dialogue and collaborative efforts, we hope to address the challenges within our housing system and work towards sustainable solutions. To officially start our event, I am pleased to introduce the Reverend Dr. Jones, who is the Director of Christian Education here at Big Bethel, who will offer us a warm welcome and set the tone for our discussions. Reverend Dr. Monica Jones, the floor is yours.
Thank you very much, Madam Facilitator and Moderator, and to all of you, welcome to Big Bethel. Let us pray. God, we thank you for this opportunity to come together as we serve your people. And so no matter the denomination, no matter the belief system, we all know that as servants, we must do what is best, what is just, and what is right. And so let all that we do be pleasing in your sight, O God. This is our prayer. Let everyone say, and so it is. Welcome. And on behalf of the Reverend Dr. John Foster, the Big Bethel A&E Church family, we proudly say that we are one of the leading churches in this community that believes in committing ourselves to the community. And that means not just being open on Sunday, but Monday through Saturday doing the work of our Lord God. And so I do welcome you, and I thank you for this opportunity to partner. I'm sure if Dr. Foster were here, he would say, welcome, welcome, welcome.
Thank you, Reverend Dr. Jones, for that heartfelt welcome. If we could begin with the slides. Now, as we delve deeper into today's topics, I'd like to start by giving an overview of the Magistrate Court of Fulton County and its central role in our housing system. I'm going to say next. There we are. The Magistrate Court serves as a holding place for most of the landlord-tenant actions in Fulton County. This means that many of the critical processes and decisions impacting housing stability, from evictions to rent disputes, take place within our Magistrate Court. During today, please go back to, yes. During today's discussion, I will talk about the structure of our court. We'll talk about the key statistics, give you an overview of the landlord-tenant process. We will immediately talk about our recent court reforms and initiatives, the impact that those have had, as well as our plans for the future. Next slide. While my aim is to give you a comprehensive understanding of how the court functions as the central hub for the landlord-tenant actions and how it supports and empowers our community, I look forward to engaging with you. Our court structure operates 24/7, 365. We have civil as well as criminal jurisdiction, and we have operations at the North Annex, the South Annex, Central, as well as the jail. In terms of an organizational chart, we have one chief magistrate judge who was elected and is supported by 10 full-time magistrate judges and 16 part-time magistrate judges. What's important here is I'm also going to give you some of the other people that work with us. We have 10 ORCA staff, and why is that important? Because that staff, that ORCA program will be ending, so much of what you see here today will be impacted. We do have 10 permanent staff who will be with us. Next slide. When we started off 2024, this is the state of our court. We started off with 41,000 open cases across all case types, and specifically as it relates to landlord-tenant cases, we had about 13,000 open cases. The writs we reviewed in 2023 was 15,000, a little over 15,000, and so we started off 2024 thinking we were in good shape. And then the Board of Commissioners hit us with a minus $780,000 from our budget. And the reason I mention that is, again, it's going to affect how our court operates. Next slide. We started with what it is we knew and what it is we could do. What we knew in 2023 was that we closed 13,388 landlord-tenant cases. And while that was impressive, we also do more than just landlord-tenant. So I've placed up our other case types, our criminal matters, our civil matters, so just know we're not just sitting in court wondering when the next landlord-tenant case is coming. We are working on our other cases. Next slide. In terms of the overview for our landlord-tenant process, you will see that it begins when the landlord files the affidavit. This is a fast-moving process. That is why it is important for this court to operate efficiently, but it's also important for this court to operate in such a manner that is fair for the people walking in the door. You can see this, and I would encourage you all, as you look at these slides, you will see them again on our Instagram. Instagram is Magistrate Fulton, and so I would encourage you to go there. But the point of this is that on its best days, landlord-tenant process is a fast-moving process, and we have help for tenants with Legal Aid of Atlanta, as well as with our housing court assistants and our landlords. We have several of our fine landlord attorneys here if you are seeking their assistance. And so, next slide. As we continued looking to how it is we are going to operate with the budget deficit, understanding that our staff was being depleted, we had to figure out how we were going to move forward. And how we decided to move forward was we increased the number of courtrooms that we had for landlord-tenant. We also established a landlord-tenant stakeholders working group. Many of the individuals that will speak today are a part of our landlord-tenant stakeholders working group. One of the issues, or several of the issues that we looked at, were how the Postal Service was working, the lack of delivery of our mail, or slow delivery of our mail. We created a mandatory mediation calendar, and then the motion to compel payment of the rent. Motion to compel payment of the rent is something that I believe Mr. Hughes is going to be speaking of today. And then, so we thought we were sitting pretty, right? So we were all excited, and then new legislation came. And so next slide. Our next slide is going to be one of our Instagram notices. I'd encourage you to go there. It tells you how to sign up to get an e-notice so that you will actually receive notice of your court date when you are signing up on a civil case. Next slide. The next is a reminder about our mediation then court. What that means is we have now 2 court dates that are being scheduled. The first date is a mediation only calendar. These are for our old cases. That calendar runs simply for mediation, and then you are given notice also for a trial calendar. So those are the 2 pieces that are running there. In terms of the other item, which is our motion to compel payment of the rent, as these cases are pending, landlords are still owed money. And so we as a group sat and figured out how we can determine and ensure that landlords were receiving their rent. There is a statute that exists, and so we want to be able to do that kindly and appropriately. So we've been providing people notice, hey, this is a provision in the law, and it will be moving forward. Again, please check our IG. And so you may be asking yourself, what were the results of this, right? That's what I'm asking. And so Let's switch to the next slide. The results are that if you look at our June numbers, so our June numbers say that of those cases from 2012 to 2022, we had 945 cases open. Here is the difference. In those cases that had been 10,000, those cases are now down to 2,673. And so it is the work of these amazing people here, the staff that is here for our team, as well as the landlord-tenant group that make this possible. You see our stats for the other case types, and I want to always remind you that we don't just do landlord-tenant cases. Of the 356 cases that actually had mediation, of those cases, 88% success rate, so that cut out our number of days in trial because those people had actual agreement, so that set us forward. In terms of our future plans, next slide, we will continue to collaborate with our stakeholders. We are making great strides with them and really appreciate what it is they have done. We will continue to do periodic process review and improvement. We may expand our mandatory mediation calendar, and we will continue to ask and beg and seek to restore our budget operations. You will hear that budget is not just an issue for us. If you have seen any of the Board of Commission meetings, you know that budget is a big deal for all of us. But we are committed to continued operation of our magistrate court in some form or fashion. Next slide. We are other direction. Next slide. So it should be the slide that says questions. And I'm going to have to depend on Maria to see if I have any room for questions. But while you all are thinking of questions, I do want to introduce members of our team that are here. Judge, if I could have you stand as I call your name. Judge Kimberly Charles, Judge Catherine Cora, Judge Todd Ashley, Maria Banjo, who is our senior staff attorney, and Karen Bostic, who is our court administrator. So these are the people that you will see and will be able to have contact with that make our court run. Were there questions for me, and how is my time? I'm good on time. Any questions? Perfectly happy not to answer any. All right. Yes, sir. Can he use a mic?
And thank you to Big Bethel for having us tonight. Judge Kirk, what do you think needs to be done to impress upon the Board of Commissioners the need to return the $780,000 that's going to so tremendously impact our operations?
Thank you for that question, Judge Ashley. And so the bottom line is we need the community's help. You all see the work that we are doing, and you see that we have been tirelessly doing this work. We have made this a court that you can be proud of as a community. And so I would say, please implore your commissioner, if there's someone you know, speak to them. It does not make sense for individuals that require additional time to have to be rushed through the process or to be made to not feel like they have been seen. There's one other question. Yes?
Does that mean we need to come to City Council?
So you need to come to the Board of Commissioners meetings. They are on Wednesday
Okay.
at 10 o'clock. And so budget was a part of the discussion yesterday as it related to the millage rate, and they have determined that they are going to set the millage rate at 8.83 despite the needs across justice for not just us, but the courts, the jail, the district attorney's office. And so services will be impacted. So yes.
Okay, is there going to be a follow-up meeting so that way I can send a blast out to some additional property managers and Atlanta Housing, because we're all impacted by this tremendously?
Thank you for that. So there are continued Board of Commission meetings. They happen every 2 weeks, and so you can check their schedule on the Fulton government website. But yes, please, we need the community to be active. Thank you. I've got 3 minutes. Any more questions? Wonderful. Thank you very much. Let me go to the next slide, it should say squatters, Georgia Squatters Relief. Thank you. Our next presenter is going to be R. Kyle Williams, who is a founding partner at Williams Tusick. He serves on the executive committee of the Real Property Law section of the State Bar and has been recognized with numerous honors in litigation, land use, and zoning for more than a decade. This Squatters Reform Act is Kyle's wheelhouse, and so I will now turn it over to Attorney Williams. Thank you.
Thank you to Big Bethel for having us. I'm Kyle Williams. As I say, I'm a dirt lawyer from Decatur. We used to be a little law firm. We now have 13 attorneys with us, and we do everything related to real estate and dirt. We are not your residential closing law firm. We are who you call when you come home from vacation and there's a squatter in your house. Or you can't close on your house because the seller refuses to show up at the closing table. We try to help solve problems. First slide, if we can. Right there. Where? Well, I'm not going to tell anybody that doesn't read the news that we've got a lot of squatters in Metro Atlanta. Squatters everywhere. That's what I say. According to a 2025 survey of the National Rental Home Council, there were 1,200 illegally occupied homes in Metro Atlanta alone. 35% of those are in Fulton County, 25% are in DeKalb County, 20% are in Clayton County. And Kayla Abrams, who's an attorney with our firm back in the back, can testify to that breakdown, but we think that number's low. The next slide, the reasons are vast, but it's opportunity and housing needs. There's an estimated 72,000 single-family homes in Metro Atlanta that are owned by institutional investors, everything from the global real estate investment trust that we hear about to mom and pop that own a few rental homes that they make some income on. In Metro Atlanta, 72,000. We are the largest city area that has that big. The next largest is Phoenix, which has 35,000. The other is everything that we all know. Rent's too high. Metro Atlanta rents have jumped up 34% since the pandemic here compared nationally to 29%. And technology has made it so much easier to identify where these homes are, how to get in them, how to get a showing to get in them, and how to stay in them. Next slide. The Georgia General Assembly, as Judge Kirk talked about new laws, this was one of the new laws that was rolled out, the Georgia Squatter Reform Act, HB 1017. Our firm tried to play heavily, as a lot of folks did in this room, in implementing that bill and shaping that bill and trying to rough out some of the rough edges. We were not successful in all of them, but the Georgia General Assembly passed this with overwhelming bipartisan support. The House of Representatives voted 167-0. The Senate voted 54-0. They wanted this bill. They wanted the headline, "We're getting tough on squatters." This was signed by Governor Kemp on April 24th, 2024. And one of the reasons why we're struggling with this is this was effective when he put his pen down. So that did not give my team, your team, the courts, the sheriffs, anybody time to figure out what the bill actually said, what it actually meant, how we were going to implement it, more importantly, how we were going to pay to implement it, especially with all of the funding shortfalls. Next slide. The Squatter Reform Act bill basically split into two squatters, civil and a criminal side. There's new criminal prosecution of squatters under this Reform Act. It creates a new criminal trespass of unlawful squatting. Now, we all know that breaking into somebody's house and living there without their authority was probably already against the law. I mean, I'm a redneck from Tennessee, but that makes sense to me. But it actually put a new line item in there that defined unlawful squatting and said unlawful squatting is when a person commits the offense of unlawful squatting when he or she enters upon the land or premises of another and resides on such land or premises for any period of time, knowingly acting without the knowledge or consent of the owner, rightful occupant, or an authorized representative of the owner. We needed the General Assembly to tell us that, apparently. But, next slide. It did outline what would happen in that situation. Criminal prosecution for unlawful squatting. Law enforcement issues a criminal citation for unlawful squatting. The property owner calls the sheriff, calls the police, and reports that someone is squatting in their home. Law enforcement is supposed to go out there to issue a criminal citation for unlawful squatting. The squatter has 3 days to provide authorization to continue to occupy that property by presenting a lease, proof of rental payments, some letter from somebody who says I can live here. If no documentation is provided, the squatter, law enforcement returns after those 3 days. Squatter is arrested for unlawful squatting, subject to conviction upon trial and conviction for a misdemeanor punishable by a fine not to exceed $1,000 or 12 months in jail. If documentation is presented, then the magistrate court, who has all the time and all the money to do this, the magistrate court gets to hold a hearing within 7 days, because y'all don't have a heavy docket already, and may order ejectment of the squatter from the property and award civil fines to the property owner equal to the fair market value of rent that the owner should have received. Next slide. The civil portion of this, which is where my firm is playing or trying to play heavily in, is a civil intruder affidavit, the squatter affidavit. This system existed before this law. It was a little antiquated, a little outdated, hard to understand, out of our wheelhouse, because this isn't a landlord-tenant relationship, so this isn't an eviction, this is an ejectment, so it's a little hard to implement, and we've struggled with it. Under the new law, the property owner swears out and submits an affidavit to the sheriff, and the affidavit said, this is my property, I own this property, I'm the only one who's supposed to be living there, somebody else is there, they're not supposed to be there, please put them out. The sheriff serves the squatter with the affidavit and a notice to vacate the property within 3 days, or present a counter affidavit establishing a good faith claim to continue to occupy the property, a lease, those rent payments, some good faith claim that they're supposed to be able to stay there. The sheriff returns to either eject the squatter if no counter affidavit is presented. If a counter affidavit is presented, then once again, our Honorable Magistrate Court holds a hearing to determine and evaluate the validity of the documentation. The Magistrate Court may order removal of the squatter from the property and award civil fines to the property owner equal to the fair market monthly rental rate and other monetary relief. One good thing that did happen with this Squatter Reform Act, it did remove from the old act the squatter's right to a jury trial, which was good. We have started operating under this in DeKalb. In DeKalb, we have both done the service of the affidavits through the sheriffs, where they go out there 1 week and they say, we're coming back next week. If you're still here, you got to get out. 85% of the people got out. They had existing warrants. They didn't want the police to come back and start looking at driver's license and license plates and figuring out who you are. Folks aren't living in a house because they need to, they have to. And so most of those people got out. We also have a situation, and Kayla Abrams tried case number 1 in DeKalb County under this statute in Magistrate Court, where a counter affidavit was submitted. And we were successful in that because it was a fake lease and it wasn't a situation that was proper. So, that's the new Squatter Reform Act. Any questions? How am I doing on time? Yes, sir.
I'm somewhat struggling with the idea that you could send an officer to your house, and somebody's in the house that shouldn't be there, based upon your own testimony, or however you all do it in Georgia. I'm from Florida, so excuse me, because I'm really struggling with this, and I'm pretty liberal. You're in my house. I'm telling him they're in my house without my permission. How's that any different than a breaking and entering?
It shouldn't be, in my opinion.
So I had to let him
But-
have my house for 3 days and do all kinds of damage to my house, probably with no job, any way of paying for it, and that's okay?
No, I didn't say it was okay, and I didn't say it was right.
Okay,
and I
that's
didn't
the
say I
law, I'm
agreed
sorry.
with it.
I'm better informed than that,
Here's the
and that's the
situation.
law in this state.
It's not necessarily, it's the system. Because everybody that shows up, when the police show up, whoever those squatters are, they all have a good story. They have a lease. They have proof of rental payments. They talk to somebody. They have copied my client's logos and put on a lease. They know who owns these properties. We talked to so and so. The last one that we ejected, they said, this was my brother's house and he's in jail, but I've got permission to stay here. We were like, we can run whether your brother's in jail or not, and we did. It is, and this system and one of the things that this law hoped to help was getting us out of the mindset of treating squatters under the landlord-tenant framework, because that was the knee-jerk reaction, especially with sheriffs and marshals and police that showed up with you. If anybody put up a lease, then the sheriff or the marshal or the police would say, this is a civil matter, you gotta go to court. I'm getting cut off, but I got a judge raising his hand, and I'm never gonna.
I'll be very quick. And so we see this case just about weekly. A tenant who is basically a bona fide purchaser, has a lease, has been making payments, but it turns out what has happened is that the person they're making payments to, whom they've never met face to face, basically ripped pictures off the internet and went on Google Docs or Legal Pro or whatever and got a lease. And so they're making payments to someone who doesn't own the property. Tenant doesn't know that. They're basically a bona fide purchaser at that point. Does the new statute address that, or is the outcome the same regardless? Because if the question is, what can you present? Can you show you've been making payments? What if through no fault of the tenant you've been making payments to a scammer?
I don't think the statute allows for that scammed tenant, let's call him that, to stay in that property, because those payments were not being made to the property owner. The property owner still has the right under that, and I think it would then be a situation where that scam tenant would have a claim. We hear that story 800 times. We probably have 1,500 active cases, squatter cases right now. We have heard every story under the sun. Frankly, 98.5% of them are a really good story. We also have repeat customers. One of my great attorneys fell for a sob story from one of them about illness, new child, laid off, paid a landlord, found this through, and the client said, we know her. She's been in 3 of our houses over the last year. No, they're playing the system. They're playing the system just because it takes time. I'll give you my consultation rate. Thank you all.
No, seriously, I really want you to have, because we're gonna have the rest of the panel up here. I know, you saw, these are our experts. And so next, if we could get the evictions by off-duty police officer, as Marshal Maria McKee is coming. I'll tell you briefly that Marshal McKee was appointed by the Fulton County State Court Bench and sworn in on December 19th, 2019. She is the 14th Marshal of Fulton County and the second female to hold this position. Marshal McKee officially began her term as Marshal on January 1, 2020. We are overjoyed to have Marshal McKee here and as one of our partners in this discussion. Marshal McKee.
Thank you. Good evening, everyone. Thank you to Big Bethel for having us here, and thank you, Judge Kirk, for inviting me as well. I am going to briefly cover the new House Bill 1203 that came out of the General Assembly on came out this year, but it was signed into law on April 24th. Before I get into So before I get into that, I just want to tell you a little bit about us, the Marshals Department, and what we do in Fulton County. We are one of 3 law enforcement agencies that operate within the Fulton County government. You have the Fulton County Police Department and the Fulton County Sheriff's Office, and we are the marshals. So we primarily are responsible for handling all of the orders, all of the writs, all of the precepts, and the like that comes from the magistrate and the state courts. In addition to that, we provide law enforcement services throughout Fulton County. Some of our additional duties are we enforce the dispossessory actions, we execute eviction writs, we execute criminal warrants, we levy on real and personal property to settle judgments, we provide courtroom security. We do so much. I'm forgetting some. Forgetting some things. We also provide state-mandated training through our regional academy. And I'm sure I left off some things, but that's just a little bit of what we do, and I wanted you to know exactly what we do. In Fulton County, we have an authorized staff of 71, 56 sworn officers, and 15 civilians. We are broken up into 4 divisions, and they are court services, evictions and warrants, civil process, and administration. So yes, we do an awful lot with a very limited supply of resources. But we're here and we're doing it. Next slide, please. I'm gonna go ahead and jump into House Bill 1203. It is an act, 484, and it became effective, as I previously mentioned, April 24th, 2024, at the signature of Governor Kemp. Next slide, please. So the purpose of House Bill 1203 was to authorize landlords to use certain off-duty sheriffs, sheriff's deputies, constables, marshals, or other individuals whom are certified by the Georgia Peace Officer Standards and Training Council to execute writs of possession in certain circumstances. Please remember the certain circumstances, because we will get to that in just a couple of seconds. Next slide, please. This act amends OCGA 44755, and that code section relates to the execution of writs of possession in dispossessory proceedings. Next slide, please. So historically, the execution of writs of possession and dispossessory eviction proceedings have been the business of sheriffs, constables, and marshals. Note, I did not mention municipal police department. It has historically been our business. So that is what we do. Next slide. With the new law, it brought about 4 new provisions, and we pull those 4 out, and that's what we'll cover tonight. And those are, number 1 is the landlords are entitled to utilize the services of off-duty peace officers. The second one is, it talks about a list of authorized off-duty peace officers. It also speaks to, it really didn't speak to, but it listed something about administrative authority of the sheriff, the marshal, or the constable. And the 4th was the duty of the landlord to notify the sheriff, the marshal, or the constable, and we'll kind of go through that briefly in just a second. Next slide, please. Okay, and this comes directly from the House Bill 1203, and this is the first point, and here's what the House Bill says. In the event the sheriff, the constable, or marshal is unable to execute the writ within 14 days from the landlord's application or request, for such execution, a landlord shall be entitled to utilize the services of an off-duty sheriff, marshal, or other individual who is certified by the Georgia Post Council. So that's the Georgia Peace Officer Standards and Training Council. Having authority within the jurisdiction wherein the premises lie to execute such a writ at the landlord's total cost and hold on 2 minutes. Landlord's sole cost and expense. So see, it's underlined. Note the note what's underlined because it really means something. So the issue here was the 14-day threshold. So for the purposes of complying with the provision of this House bill, we deem the 14-day threshold period to start from the time when the judge actually signs the writ and not from the time of the application for the writ. So the writ can't be executed until it is lawful. It is not lawful until that judge actually signs the writ and date it. So that is the date where we will start the 14 days. Next slide, please. Number 2, the second point talks about the sheriff, the constable, the marshal shall maintain a list of authorized off-duty sheriffs, sheriff's deputies, constables, marshals, or other individuals who are certified by the Georgia Post Council to maintain that list and make it available to the landlord at their request. Right? Not security guards, if you would say. So the next slide, please, just shows the application for listing, and this is an application that we are making available for individuals whom would like to be considered to be on a list. Next slide, please. Yeah. So that just shows that application. However, being on a list is definitely voluntary. So we don't go out and solicit, and we don't force people to be on a list. Here you go. So the observations that we made was that a landlord is not required to utilize a listed peace officer to execute a writ while off duty. However, the landlord must utilize a Georgia Post certified officer having jurisdiction wherein the premises lie. So they must have jurisdiction. And next slide, please. Okay, so the third point was that the sheriff, that we should maintain some administrative authority over persons executing writs under the subsection. However, that wasn't fleshed out quite well. So I won't talk that much about that. I did talk to the attorney, and he's gonna do a cleanup on that point. Looking forward to it. Finally, so that I can stay within my time, the requirements of officers who will be executing these writs, they have a duty to advance the slide for me, please. Thank you. They will have a duty to execute the writ entirely. So don't start a writ and stop in the middle of the writ. You do have a duty to completely go through the full process. They must turn over the property at the completion of the eviction to the landlord peacefully. And they have a duty to make and file an entry of execution with the appropriate clerk of court at the completion. And so in a nutshell, there it is, House Bill 1203. It is something, I tell you. We're working on it. Yeah, we're all working on it. It is definitely something new. It is not something that the local police are used to. So they're not just that well versed in civil matters. And so, you know, it's slow to roll out, but I believe it will get fixed and roll out. Thank you.
Thank you. And so our next section, if you could put the slide up for motion to compel rent payment, and as Attorney Hughes is coming, I will introduce you to him. After a long and distinguished career in executive leadership at a restaurant company, Mr. Hughes went back to school to achieve his lifelong dream of becoming an attorney. Mr. Hughes graduated from Georgia State University with a joint JD MBA, and he has spent the last 10 years in landlord-tenant law as a mediator and attorney, and currently represents landlords for predominantly apartment communities. Mr. Hughes.
Thank you so much. Thank you, Reverend Dr. Jones, for up your house of worship for us. Thank you also to Judge Kirk, who has been leading a task force in Fulton County. She was able to demonstrate much of the progress that we've made as a working group. Things are markedly different this year versus last year in terms of number of cases and the ease of doing business in Fulton County. And for that, I deeply appreciate it. So, unlike many of the panelists this evening, I'm not talking about new legislation. I'm talking about existing legislation, which is the motion to compel. If you would advance to the next, actually, one more. All right. So there is existing law, OCGA 44754, if I get my glasses. And I will not go through this line by line. I will point out one very important word, and that is shall. So under existing law, it basically said that if a case could not be finally decided within 2 weeks of service of process, a tenant would be required, shall pay in the registry of court all rent and then ongoing rent as it became due. And so in the next slide, I have translated that into English. If an eviction case cannot be scheduled or finally decided in 2 weeks from when the tenant is served, the tenant can be ordered to pay all back rent and all future rent in the court's registry. Importantly, this is not a law that is self-effectuating. That is to say, it's incumbent upon the landlord or their representative to actually file a motion in order to make this happen. And so, while this is not a new law in the state of Georgia, it is a new focus by those of us in Fulton County to emphasize these motions to compel as a way of highlighting these sorts of cases where there are high balances and it's an opportunity for landlords to then ensure that money gets paid into the registry. The cases don't sit dormant. And I should mention that one of our other panelists will be discussing the motion to compel from a tenant's perspective. This is really from a plaintiff's attorney perspective that I'm talking about now. Next slide, please. However, I will point out to tenants a couple of, I think, what are important components to the motion to compel. And so I draft a fair amount of these, so I've seen these. In the top right-hand corner, there's a very brief summary, and you can see it on the slide, where it gives the amount that is due and the time frame by which it's due. So this is the rent arrearage, that top first line. And it tells you when you have to pay and how much you have to pay. And that is 14 days from the filing and mailing of the motion to compel to the tenant. So we file it online and we also mail a copy to the tenant. By the way, as I'm talking about this, just a brief appeal to any residents that are in attendance. I encourage you to, if you have an eviction action, sign up for the email notifications, because mail, as you know, is it's a lottery system whether you're going to get your mail or not. But if anything is filed in your case, i.e. a motion to compel or a hearing notice, you'll get automatic notification if you sign up for the email notifications. In any case, the second part is that you are, the resident is required to pay rent as it becomes due. So by the 5th of each month following the filing of the motion. Now, there is an alternative to paying rent into the registry of court in certain circumstances, so that if a resident has some objection, that is, they've already paid rent, or they disagree with the amount of rent, monthly rent that's owed, or if they have sufficient repair plans that offset their rent, they can make an objection. They have to do that within that 14-day time frame. And if they file that objection, then a hearing gets scheduled to determine how much money is owed into the court registry. Um, and then the second thing I wanted to point out is that each of the motions have two other things that are listed in the motion. The first is it has a notice to tenants, so it sort of thumbnail sketches their rights and obligations under the motion. And then the second thing is we send a copy of the standing order because the motion refers to the standing order produced by Fulton County that direct the residents as to what happens if they don't name the registry or if they don't object. And I have maybe 30 seconds for a question. All right.
Thank you for joining our panel. I will tell you that the court has also produced, along with our stakeholder group, brochures as they relate to the motion to compel. They are on the back table. It is a step-by-step as well as a frequently asked questions, so we do have those available. If I could have the slide about Landlord Considerations and Safe at Home Act. That will be presented by Attorney Mike Williams. As Attorney Williams is coming forward, I will introduce you to him. He is an attorney with the law firm of Fowler, Hine, Cheatward, and Williams, PA. He has been in the practice for 30 years. His Atlanta-based firm limits its practice to representation of single-family, multifamily, and commercial property owners and managers. Mr. Williams formerly served as a sergeant in the Army National Guard and currently serves as the District 7 legal officer for the United States Coast Guard Auxiliary. He also serves as chief counsel for both the Georgia and Atlanta Apartment Associations. Attorney Williams.
So I got 10 minutes. That's hard for a lawyer. So I will. Next slide. All right, next slide. All right, so I'm here to talk about 404, the Safe at Home Act, and I'll try to be brief. Next slide. And what brought about the Safe at Home Act? Anyone know where this is? Forest Cove, right? Next slide. More pictures from Forest Cove. Next slide. What it looks like now before it gets demolished. Next slide. And here's kind of the result for the city, which is not, you know, too good. Look at how much money it's going to cost the city, over $2 million, to demolish it and kind of go from there. Next slide. All right, so the Safe at Home Act is broken down into several different areas. The first of which is, it talks about the duty of repair and habitability. It requires all landlords to be liable for substantial improvements made with their consent. That's the first aspect of it. The second part of it is it requires them to keep the premises fit for human habitation. So, prior to this, there's a duty to repair, always been a duty to repair on behalf of the landlord under Georgia law. This codifies it and makes it clear that they have to keep the premises, fit for human habitation. The next aspect of it is they've added cooling to utilities that cannot be shut off. I assume they're meaning air conditioning and so forth. I haven't had any cases where I've seen landlords shutting off the air conditioner, but in any event, they would be prohibited from doing so. The next aspect in summary is the security deposit cap. We now have a cap of 2 months rent on security deposits. Just keep in mind if your property is located in the city of Atlanta, then you have to meet the city of Atlanta ordinance, which means if you're required to allow 3 months payment of the security deposit or post a bond, you can't just require the full amount due and owing. Next slide. I'm going to talk about the last part. The law goes into effect July 1, which is now just a few days away. However, it's only for new leases and renewals effective July 1. Doesn't apply under prior leases. It makes it kind of tricky. We are obviously advising our clients to start following the law effective July 1 so that we're not having to figure out whether this is a post-July 1 lease or whether it's a pre-July 1 lease. So most of our clients will be go ahead and issuing the notices and following the 2 months and so forth from here on out. The most important part of this is how things have changed with respect to the filing of dispo. Prior to July 1, you simply had to make a demand for possession prior to filing for non-payment of rent. For example, I could just come up to you and say, hey, you haven't paid rent for the month of June. Demand is hereby made for possession, and I could file. I could do it orally. I could do it in writing. Most of the professional landlords do it in writing. The new law requires something a little bit different. It requires two aspects of it. Number one, it requires a posting on the door of a 3-day notice to pay or move. So basically, you write a letter and you say, here's the total amount of rent due. You got 3 days from receipt of this notice in which to pay or move. That notice has to be put in an envelope, sealed, and placed on their door. That's method number one. No questions asked. Can't get around that. It has to be done in every case. Second aspect of a second copy must be sent by one of the methods provided for in the lease agreement, whether that's email, first-class mail, certified mail, whatever is required by the lease agreement or method that allows you to send it, it has to be sent by that method. So posted on the door and also sent by one of the methods provided in the lease. Now, the other little nuance of the law is you do not have to do this when it comes to termination of leases to put them in holdover state, meaning that if you're non-renewing a lease agreement or your lease is non-renewed, the landlord simply can send it by the notice provisions of the lease agreement. They don't have to put it on the door, although I'm going to encourage them to do so. They don't have to do that. However, if that time passes and they continue to remain in possession, it's time to do the demand for possession. The demand for possession must be posted on the door and sent by one of the methods in the lease. So all demand for possessions, whether it be a 3-day notice or failure to pay rent or demand for possession after holdover, has to be posted on the door in a sealed envelope and sent by one of the methods provided for in the lease agreement. So to me, that's the most significant change. So for example, most rents due on the 3rd or the 5th. So assuming it's due on the 5th and the late letter, the 3-day notice goes out on the 6th, it's posted on the door. And by the way, it's 3 business days. So if it falls on a Friday, it means you got to count Monday, Tuesday, Wednesday if you're sending it out, and then you could file after that 3rd business day. So you have to make sure you allow the 3 business days in order to do it. It's really put into place to put everyone on notice, hey, this is your opportunity to pay. This is your 3 days, you pay it, you pay the late fee, and you can remain there. And so if it's not paid, then the dispossessory action can be filed. And that's the most significant change in the law from the demand for possession to the 3-day notice. See if I missed anything. I think that's it. Thank you.
Yes.
Yes, sir.
I know that this was called the Home Safety Act. I am a commercial property manager, and I wanted to know, does this have anything to do with commercial? If not, is there any rules to commercial as far as the holdover and the dispossessory that you were just explaining for the Home Safety Act?
So this is really targeted to residential. I mean, commercial is like in their own, it's in its own bucket, so to speak. In other words, many of the commercial leases
So, the holdover and everything like that, no,
Well,
none of
you
that.
would have filed rolling over if they're holding over
But
on the term and you've given proper notice, or if it just expires by its own term, which a lot of, commercial leases do.
okay, thank you.
Good question.
I think we have one more.
Attorney Williams will have a seat up here, so at the end, when we have time left, we will have an opportunity to ask the full panel questions. And so now we're going to hear from a tenant's perspective. I'm going to invite up Margaret Kinnear, who has been with Atlanta Legal Aid Society, Inc. since 2000. Although she primarily practices landlord-tenant law, she also represents clients with issues related to unemployment benefits, Social Security benefits, and other public health benefits, as well as consumer issues. When not practicing law, Maggie fosters pets for people who are between homes with pause between homes. Attorney Kinnear.
Thank you, Judge Kirk, and thank you, Reverend, and everyone at Big Bethel for opening this beautiful church up for us this evening. Land Legal Aid actually turned 100 years old earlier this month. We are, thank you. We provide civil legal services to low-income citizens in the five-county metro area. Our sister organization is Georgia Legal Services. They handle the rest of the state. Next slide, please. Oh, next slide, please. Thank you. All right. I'm going to talk a little bit about the Safe at Home Act, which Attorney Williams just talked about. These are kind of the main provisions. Agreements to rent residential property now have to include a provision that the home is fit for human habitation. The utilities the landlord furnishes now include cooling, in addition to heat, light, and water. Security deposits cannot exceed an amount that is twice the monthly rent. And before filing an eviction for non-payment or other charges, the landlord must give the tenant a notice to vacate in writing and provide them 3 days to either pay the balance or vacate the property. If neither one of those things happen, an eviction case would follow. Next slide, please. Wanted to talk a little bit about fit for human habitation. It's not defined in the law, but the law does require that the landlord shall keep the premises in repair, which basically means the landlord has to maintain the property by performing needed repairs, and the property has to be in a condition that at least meets the minimum housing code standards and requirements, basically so people can live there and be safe. If tenants have a repair issue, please make sure that you give your landlord written notice of the need for a repair. That could be an email or text message, but do check your lease to see if it has a specific requirement, such as a notice or a written letter or something like that. And please do not withhold your rent. Georgia law considers the tenant's obligation to pay rent to be separate from the landlord's obligations to make repairs. So if the landlord is not making repairs, withholding your rent is not the way to get them to do that. So please don't withhold your rent. Thank you. Next slide, please. Going to talk a little bit about the motions to compel, which Attorney Hughes talked about. It is 14 days from the date of service. Apologies for the typo in my slide, but it is 14 days from the date of service. If the hearing can't happen in that time period, then the landlord can file a request, they can file the motion to compel the rent to be paid into court. And as Attorney Hughes pointed out, the law does require that that motion be granted. That is calendar days. These are all going to be calendar days. The tenant will have 14 days, 14 calendar days to file a response, and they would have 15 calendar days to pay money into court. Please note that the file a response, the court will then hold a hearing, but again, please make sure that you're still paying at least the amount of rent that is not in dispute into the registry of the court while you wait for the hearing. If the tenant has counterclaims, such as the landlord hasn't made repairs, that is something that needs to be filed with an answer, and counterclaims, that is not something that would be a response to a motion to compel. Even if a motion to compel is filed in the case, whatever ends up happening with that, the court will still have a hearing on the issues between the landlord and the tenant, which would include any counterclaims the tenant might bring for failure to repair. So that would be part of that hearing. But my landlord has failed to make repairs, and I think they might owe me some money. That's not part of the response to the motion to compel. The only thing that would be, again, is that my landlord is claiming I owe a different amount of rent than I actually do, or I have made payments. Next slide, please. Okay, very quickly, before somebody far more knowledgeable than I talks about rental assistance programs, I do want to let everyone know that the Atlanta Legal Aid Society is still working with the Department of Community Affairs to refer people who are currently on our wait list to DCA for their rental assistance program. So we don't actually have any rental assistance. We're referring people to DCA. The wait list for that program is currently closed. Our website will include any updates if and when the wait list ever reopens, and that information can be found there. Just so you know, we started referring people last August, so August of 2023. Since then, we have dispersed over $17 million, DCA has, for people we referred to them, has dispersed over $17 million in rental assistance, approximately $7 million in Fulton County. Does anyone have any questions? Please. Thank you.
And on the topic of rental assistance, our next presenter is come up, but as Angie Santee comes up, I would like to also mention that It Still Takes a Village provides rental assistance in both state court and magistrate court, and since January 2024, that program has served 564 families to a total of $1.3 million providing rental assistance. So there is still rental assistance that exists. You have to look hard to find it. Turning to Angie Santee. Angie is the partner and vice president of operations at TIA Asset Management. She oversees the operations and management of mixed portfolio of commercial and multifamily properties. And during her free time, when she is happy to lend a hand, her passion lies in helping to feed and house the homeless community, animal rescues, and child advocacy. She has 2 grown sons, 3 rescue pups, and 2 grand pups. Her favorite pace is on the beach with family and friends, soaking up the sun and sea breeze. Welcome, Angie.
Thank you so much, and thank you for having us here tonight. I really appreciate it. But here's a funny story. I was told I was coming here to talk about the landlord's perspective of evictions and how we can help. So I am not the expert on rental assistance for the city of Atlanta. I am here as a landlord saying how we help our tenants get through their challenging times. So I will go through the slide that was given me, and actually I'm actually kind of standing in for somebody else also. So if we could have our slide, next slide. So we are TI Asset Management. We also have a nonprofit called Star C, which is our nonprofit that does run the eviction relief program. Next slide. These are a few of our properties that we have. And along with that, I just want to mention real quickly, because we did touch on Forest Cove, we were actually the scattered site management company for Forest Cove. So once they got relocated, TI Asset Management stood behind the tenants to make sure that they were still in good and appropriate, safe housing once they were moved. So that was quite a feat that we really enjoyed taking care to work with our tenants to get through these tough times, which is where the eviction relief program came with Star C. They took on the program with Fulton County and Cobb County to help our residents to get out of the troubled time of COVID is when it started. Back then, we had a mission of raising $50,000 to help our tenants, and we ended up raising $14.5 million. So that was pretty good. We are currently working with the Archie system collaborative in order to get people still the assistance that is needed. However, we have run dry at the moment. We are hoping to get another $2 million from Fulton County so that we can maintain our services, and this is only in the city of Fulton, so, or the city of Atlanta at this time. So, do we still have the slides? Next slide. With this, our biggest help along these ways is our partnerships. We have several partnerships that we have with Morehouse, for our health, for education assistance, for literacy, and all this we have to help go through with education and in order to get our residents the help that they need along with the eviction relief. Next slide. And again, their partnerships are so crucial. Next slide. Again, our partnerships is so very important. We keep going. Sorry, the presentation is really not what you had expected to hear from us, so we'll keep going to the next slide until we get to the eviction part. One more, I think we're there. So this is what the City of Atlanta Eviction Diversion City the fund is. The Star C covers up to $7,000 for rental assistance per household. It's paid directly to the landlord, not to the tenant. The tenant must have some type of financial hardship. It doesn't have to be COVID related, which it was before, but and it has to have that has some kind of effect on their income. And the family has to earn less than 60% of their area median income. And I think that is it. Yeah, next slide, please. There are several resources to get to the funds in order to go to the Star C program. If you go to, it's hard to see on the slide, but the RG Collaborative, which is very popular now throughout the area, is the way to get to Star C. Are these slides going to be given out to anybody to get these websites on the chance? Can you know? Because that would be a huge help, I'm sure, for anybody that's out there looking for assistance. These are all different areas that you can get the assistance. They're still there. As they have mentioned that it's a little bit harder to find, but there is still assistance out there. There's a lot of faith-based assistance still. And again, the City of Atlanta is looking hopefully in their next fiscal year to give out more funds for us. Next slide. And that's all we had. Sorry that I wasn't able to give you more information about City of Atlanta. Kind of took me by surprise because it's not what I thought I was going to be talking about tonight. So I apologize. But if you have any questions, I will try to answer them as best as I can. Thank you.
I have a question.
Yes.
Okay, so is it assistance that the tenant has to apply for?
Yes.
Okay.
This is something that tenant has to apply for. The landlord, previously, the landlord was able to help out. Really, this is all the tenant, this has to be in their hands. Now, what we have done with TI and our properties, it can be very daunting for residents to have to go through this. So we put on classes basically that say, how can we help you, apply for this? We'll bring out laptops, do whatever we need to do. How can we help you get this funding, what you need to get, and the information together for it? So I highly recommend helping people with it. As you get into that website and you go, what do I need to do? So.
Thank you.
Thank you.
Thank you very much. As I am about to join the panel so that we can ask questions, you all have an opportunity. Attorney Banjo is going to come up and assist with the next round as I join the panel to ask questions. Thank you. Answer questions.
Thank you. I know you've been waiting.
Thank you to Bethel Church for putting this together and to the distinguished panel in front of us. I am a new attorney to the state of Georgia, and I'm helping one client in particular, which is why I attended this event. But my question is a general one because I have not yet taken a look completely at the new law. My question pertains to the applicability. So say, for example, you have a tenant whose lease has not been renewed and is being constructively evicted. Does the new law that takes effect on the 1st apply to someone like that? That's number one. And does the law make any mention with respect to constructive evictions?
So the law doesn't specifically talk about constructive evictions, but it does talk about the landlord's obligation to keep the premises in repair, and the new phrase that's in the law is fit for human habitation. The landlord's obligation to maintain and repair the property existed prior to the Safe at Home Act. It just sort of, I guess, beefed it up a little bit. So it would, that part would still apply to a lease that was in effect prior to July 1st.
I do. I agree with that too, that assessment of it. With respect to constructive eviction, that's been the law. It'll continue to be the law. And, the key component to that is has it deteriorated to such an extent to where the landlord cannot repair it while the tenant's residing therein. That's element number one. And element number two is has the tenant vacated and returned the keys. In many instances, we face some cases. I mean, I've got really good clients, so I'm very fortunate. But in those cases where there's an argument of constructive eviction, they continue to maintain possession of the premises and not return the keys. Because the whole premise behind constructive eviction is a failure consideration. I can't live there. Here's my keys. And that's what all the case law talks about. So it's important that if you have a case where it's constructive eviction, that you actually return the keys and possession back to the landlord.
Do you have any additional questions? Oh, right here in the back.
Yeah. Hey guys, Katie Herring with ABLF. Thank you for your presentations tonight. I did have a couple of questions. One about the motion to compel payment into the registry. So I understand that the tenant has the opportunity to file a response if they dispute maybe like the monthly rent amount. But my question is then what gets paid into the registry? Because the tenant still has to pay into the registry when they filed that response. So if they're saying their rent is $900 and the landlord's saying, no, I've increased it to $1,100, and the tenant's response is, well, that increase was improper, wasn't given notice, what gets paid?
Randall and I agree. My understanding is that if the tenant files a response and says, my rent is $900, and here's my lease that says my rent is $900, the tenant has to at least pay $900 into the registry of the court, unless they have something showing that they've already paid. And then they need to also file a copy of the proof of the payment.
And that is my understanding as well. So it would be the undisputed portion.
And also one more thing, our approach is that we have a lease and the resident in front of us before we file that motion to compel. So if we think there's any kind of dispute at all, we're only going to ask for the undisputed portion of rent, knowing that there won't be a dispute. The idea is not getting a fight about how much is paid in, to maintain the status quo while the case is pending, and not just undisputed amount into the motions to compel to ensure that it doesn't get disputed. And to be quite frank with you, with that approach, we get very few that are disputed because of that approach. So I recommend, if you're a landlord, that you do that. If you know something's in dispute, don't even put it in there. Just leave it out, because otherwise you can fight about it later in court.
And then my other question was about the fit for human habitation language that was added in the new bill. Is it y'all's understanding that this imposes an additional duty on the landlord above and beyond their pre-existing statutory duty to repair? Because it seemed like in the presentation that I understand that that definition of fit for human habitation hasn't been fleshed out, but I guess my question is it your understanding that it enhances the landlord's responsibilities, or is this just a restatement?
It's a good question.
So I think it codifies what they were required to do before, and I guess it does enhance it to some degree. It doesn't change the landlord's duty to make repairs and the tenant's duty to pay rent, that independent covenant, but it certainly codifies that they have to keep the premises fit for human habitation. And again, we're really big on this on our clients, and as the apartment association, on making sure that our clients and our members maintain properties. I mean, the idea here is if you maintain your property, you're going to get the best amount of rent, you're going to have happy clients, they're going to renew, and so forth. So yes, I do think it enhances it. I don't know that it creates any additional damages or anything. You still got the same damages. You would still, if you're going to assert constructive eviction, you would still have to vacate the premises. If you're going to assert repair and deduct, you still got to put the landlord on notice, give a reasonable time, make the repair, and then deduct it from the rent. Or you can sue the landlord separately for the diminution in value. So I don't know that it changes any of that, but it does enhance it, and it certainly would enhance a constructive eviction argument.
So we do have an anonymous audience question, and the question is, how much does of what we've covered today have to do with condominiums? Was that your question? Like I think we've spoken a lot about single-family homes. Does it apply to condominiums as well?
Rentals. Okay. If they're rentals, yes.
Okay. Thank you. I hope that answers the anonymous question.
Up here, we have a question.
I got you next.
Okay. Hello. Thank you all for having us today. I have a question for the marshal. You spoke about the off-duty officers. If a landlord elects to use an off-duty officer, is there a standard rate, or do they make their own rates?
That's a very good question. Glad you brought that up. That was not spelled out in the law. So as it stands right now, off-duty officers that work jobs, they are like independent contractors. And so being that they're like independent contractors, then it'll be a negotiation between you and the officer.
In other words, be prepared to pay.
Within that negotiation, at what point say me and the officer, we negotiated the price to do the eviction, then we come to you and say, hey, we negotiated this officer is assigned. How does that process work when we contract?
Yeah, so another great question, and that's part of what we're still working on. Yeah, we just haven't got that far to flesh it all out. It was kind of written like any officer can, as long as they're certified by the Georgia Post Council, that they can do evictions. However, we do have requirements because officers have to be approved to do off-duty jobs. So regardless to who they work for, if they work for me or a police chief or a constable or a sheriff, they have to have approval to do that. And so with that approval, that department head is gonna want to know how they're gonna be liable or how they're gonna get out of being liable. So that's part of what Attorney Cal and I was talking about. That part needs cleaning up, and so we're hoping that going forward that we can get some cleanup on it.
Just one more question, if you don't mind. Just one more question, if
Okay,
you don't
one
mind.
more question, go ahead.
It was more for, I believe, the gentleman in the red tie. We were talking about the, yeah, you got the red tie on. There you go. I like that red, by the way. That's a nice red. Remind me of Crimson and Cream, your brothers. Okay. So, this lady had a question for you, said about with the, when the eviction, excuse me, I'm saying, I'm just more, when she talked about when, the tenant is fighting against the eviction. I believe she just had that question here. And she said that, the holdover, excuse me, it was the holdover. When the tenant is holding over and the landlord doesn't want them anymore, and they're paying into the registry, excuse me. So at that point, holdover rates in some contracts say if you're holding over, you're gonna pay 3 times the rent, okay? But say it was already the $900 that was established that we were already paying, but now it's the holdover time. And what does the landlord do at that point?
Okay, so your question is the tenant's holding over and there's a holdover provision in the lease agreements. And those holdover provisions have been found to be enforceable. There's at least 3 cases in Georgia that say that if your contract says if the lease expires and you go on a month-to-month and you're holding over, strike that. If you've been non-renewed or terminated and you hold over and the rental rate becomes 2 times the existing rental rate prorated by the day for each day you hold over, or even 3 times, the courts have held that to be enforceable. So in your situation that you gave, say they're only paying the base rent in the court, you would probably want to consider filing a motion to compel and include the double rent or triple rent provision. I had a case, matter of fact, in Fulton County 15 years ago, where the resident appealed a magistrate court decision, and she paid 3 times the rent in for 10 months. So it was kind of nice that I got my attorney's fees paid for, but on the other hand, it was a non-renewal, and clearly she should have vacated the premises at the end of the term. So you have a remedy. You can make the motion. You're probably going to have a hearing on that because you're asking for 3 times or 2 times, whatever the lease says. But as long as your lease has a provision like that, you can enforce it.
Judge, you have a question?
This is back to Marshall McKee. So I just want to, and I almost asked this during your presentation, but you were a little short on time. I just want to clarify and confirm, the marshal and now the post-certified officers, the off-duty officers, they don't actually go into the house and set out the belongings. Isn't that correct? There's a set-out crew. So landlords need to realize that they're just there to keep the peace. So if you have a situation, and you're probably just going to say yes to answer this question, but I just wanted to confirm. So right now, if you have a tenant that needs to be set out and you send out marshals, they're just going to stand there and make sure that there's the peace is kept, right?
That's correct, but they also have some other things that they have to do. They actually have to go in and clear premises first. They have to make sure that everything is safe for that company or those individuals who are going to do the actual physical moving of the property. And they have to stand by as well and ensure that everything is carried out legally and that it is placed in the proper places once it is on the outside. So, yeah, they have that responsibility as well.
So now with this new law, if a landlord decides to forego the services of the Fulton Marshal and hire their own law enforcement, that's an additional expense in addition to the expense of hiring the set-out crew, right?
Yes.
Okay.
Yes, but the marshal's right. I mean, how it works, and this is both for evictions of squatters, evictions of tenants and ejectments of squatters. The marshal or the sheriff tells us how big a crew we need, who we need there, if we need 6 people, 8 people, what that number is. And then they knock on the door, and then they have our lock folks actually break the lock, get in the property, and then they tell us to stand back until we're allowed to go in. And that's going to work.
We have about 4 minutes.
Okay,
Question?
I'll make this quick. This is for Marshal McKee. At the present time, I know you're in the hot seat tonight. At the present time, just a couple questions here for you. At the present time, how many writs does the Marshal's Department currently have that are pending scheduling set out? That's the first question. And the second question is
the first question?
How many pending writs scheduling for set out does the Marshal's Department currently have in their office? Because I think at your last task force meeting, I think it was roughly around 3,000. Is that number still about accurate?
That's about accurate.
Okay. My second question for you is have there been any officers that have made application to be approved? And if so, have any of those officers been reviewed and approved?
So at present, we currently do not have anyone on the list.
Got it.
We have had, I believe, one officer to come in and, ask and apply to be on the list. I believe, I'm trying to remember, but I think we've had one. So we don't currently have a list. We are working with the municipalities to talk about if they want to allow their officers to do it. So we've had a couple of meetings and discussions and just trying to make them aware of everything that goes into it. And so I said earlier that it is very slow. It's slow to roll out. I do believe it will roll out somewhat to a degree as well. We're even as well looking into how we may be able to, because right now my officers are not doing it. Because it's a little bit of a conflict for me, but we're trying to work through it and see how we can maybe clean it up some and go forward.
Officers are trying to go through their own analysis as to what's my liability, what's my exposure, who covers my insurance.
Right.
It's a whole lot different than if you're working a party after hours, which they do all the time for a little extra money. I mean, they read the news like all the rest of us. Some of those evictions don't go right.
Right.
Yeah, and so we have stayed somewhere around 3,000. I think we dropped down for a short period of time, but we just stay there. We did 200 evictions in a week, and when we got to work on Monday and opened the queue, we had 300. So what's in, what's out, it just kind of stays right there. That's where we are.
We have one question, I believe. Oh, 2.
Okay, this is actually addressed to you judges. Because there's no defined standard for fit for human habitation is going to be established by the courts, have you already come up with a standard for fit for human habitation? I'm asking for a friend.
Looks like, oh, sorry, there we are. So I think it takes a moment to wind up. In response, it would be based on case law, but since this is a new act, it's going to be building as it is determined. So it's kind of going to be like we know it when we see it until we are told otherwise by the Court of Appeals.
Understood. I appreciate it.
last anonymous question. Piggybacking on Mr. Williams' comment about the triple rent paid for a holdover, and I'm interested to hear Ms. Kinnear's perspective on this as well. When residential landlords charge late fees, and it's in the lease that say $20 a day, $50 a day, that's not the law as y'all understand it to be, right?
I would agree with you that I believe that late fees are supposed to be, according to the case law, meant to cover the administrative burden of the late rent and not, they should not be imposing a penalty.
If it becomes a penalty.
Exactly, yes, yes. Your Honor.
Okay.
And I agree with that too. I think the case law says up to 15% is sufficient. Anything above that would be usurious. And
So even though the tenant signs a lease providing for $50 per day in late fees for holding over, I get that they kind of agreed to it, but I'm pretty sure the Court of Appeals would look at me sideways, right?
I agree, and we wouldn't ask for it. We'd only ask for 10%.
Yes, I think that would be an invalid provision that would be severable.
Just wanted to confirm that analysis might be different in the context of a commercial lease as opposed to residential. Confirm, thank you.
Hi, thank you so much for having this town hall. My name is Crystal Red with the Atlanta Volunteer Lawyers Foundation. And sorry, Marshall, I just have one more question for you. And I'll tell you the perspective I come from as a tenant advocate, obviously wanting to ensure that tenants' rights are protected even in the process of a set out. I know that the law doesn't have anything specific about the type of identification and things like that as far as if it is a post-certified officer, off-duty officer who can come and participate in this process. Are you imagining that, because you also brought up the piece of officers are figuring out their own liability and things like that, are we imagining that they're going to come in their municipal-based uniform? Are we imagining that they will have some type of identification that makes it very clear? Obviously, as a tenant advocate, ensuring that the landlord has not, in fact, just hired someone to be able to come and represent themselves as being a post-certified officer. So has that part been thought out? And I have one more question, too.
Yeah, I would assume that if they are going to take on this off-duty job, that they would be uniformed officers. I can't say, I mean, it's a lot going on out there right now, and we're running into all types of situations. So it's a lot of evictions going on that should not be going on. But they should be, I would say that they should be uniformed. And so if they went through the full process, like the process that we're putting into place for them, then they will know that. So, and I would hope that they would comply, and as well, their department heads would probably require that they not do it outside of them.
We would require that from a landlord's perspective.
You would not?
We want that.
You want that, sorry.
We would, as the person hiring that person, like our internal folks have put together a checklist to even like vet the list once they get the list, because we've got questions about that too. Because we're going to want that authority there that's not just the landlord, because who's going to get sued? It's going to be the landlord if it goes wrong. And so we're going to insist on that too. So our assumption is that they will be just like this.
Great, thank you.
And we are already over time.
Oh,
If
sorry.
you could briefly say what you want to say.
Oh, and actually, Attorney Williams is actually on the Squatter Reform Act. When we find that the notice is provided to the individuals who are located in the property, are they also being told at that time? Does the document actually include information about the fact that they do have the right to file to contest it? Or is that document provided when the affidavit is served on the individual?
So under the new act, we're still kind of playing it through. so to speak, but how it is happening, at least how the ones that we have done on those new acts, is when the affidavit is served, it does include like a typical almost service of a process, sheriff's entry of service that says you have these 3 days to respond to that and how. I mean, kind of the statute kind of leaves kind of blank, like how they're supposed to do that. What's a counter affidavit? And we had those conversations even before this law passed with the sheriffs as well as the occupants as to, you know, showing your cell phone and text messages isn't necessarily what the statute requires. How most of the sheriffs are treating it as if somebody just shows a lease. They're not making a determination as to the validity of that lease. I think what we're trying to ensure is what happens with that they show, that it gets filed somewhere, that it gets sent to the property owner as well. But the idea is that they will knock on the door, serve it, tack it as well with the opportunity to respond. And then go back. I mean, what they're doing in practice is somebody gives it to them.
And so I realize that our time is up. There are 2 questions. I'm going to ask that they ask the question and hold for the response again. So we'll do a big push with the response. So just ask your question.
Sure. My question is the decision tree versus criminal versus civil on an eviction. I recently purchased a house and I have someone in and went to Fulton County Sheriff. I realized this is a new process and I was pointed to 8 different people. So it was difficult for me to understand where in that process a decision was made between either or.
I mean, hold on. We're not answering yet. Hold on. We're not answering.
Hello, I just wanted to know if there is going to be a website where a link is posted somewhere where we can get the information on, for example, if I'm a landlord or a tenant, if I decide to go with the post-certified officer, what documents I should look for or what things to look for before proceeding. That's it.
Thank you. And so I'm going to turn it over to Ms. Banjo to figure out how we answer those last 2 questions. Somebody that's got a less than 30-second response.
Go ahead. Our firm takes a position that Squatter Reform Act is not an either-or. It's not a decision tree. You can pursue both the criminal lane as well as the civil lane, and we are pursuing both at the same time. Well, we're not pursuing the criminal side, but when we serve the civil warrant, the civil affidavit, or whatever mechanism we're doing that, we're also asking the sheriff or the marshal at that time to also issue the criminal citation. We're advising all of our landlord clients that before they call us, they should do exactly what you're doing, which is call law enforcement and see if they can't get some relief that way. But I don't view it as an either or, it's a both. Because at the end of the day, you got to get possession any way you can. And attorneys, we run any horse until we see who wins.
Thank you. And for the last question regarding the form, Marcia, if you want to briefly mention.
Yeah, we're gonna take care of her.
Thank you. And we are done. Thank you guys for coming. We really enjoyed. Please clap for our wonderful presenters tonight. And thank them for spending their time with us today.